Okay. Well, I think you don't see the behind the scenes, that happens, but I think that's such a flawless experience. It has to be. Believe me. Yes. We did. Budget. Still have all of it. How much is it? Is he seen it? Actually pretty good. Has he seen it?
No, I meant to show him earlier and I forgot it.
Mr. Schmidt, who are you ready on?
Mr. Eckles, Zachary Eckles.
All right, this is cause number WR 25-11, writ hearing. Zachary Irold Eckles. Is this a writ seeking bond reduction or writ seeking probable cause?
Bond reduction, Judge, and at this point, I've had discussions with Mr. Hartwell in the state. We've reached an agreement, and if I could announce that, and then we could provide whatever the court needs, but Mr. Eckles has been in custody since March 11th on a felony charge and 1, 2, 3, 4 misdemeanor charges. At this point, none of those charges have been formally filed with court. And the agreement is that his bond is set on his felony charge at $100,000. The agreement is to leave that as is, and that he be able to post PR bonds on the misdemeanor charges. So that would leave him with a total of $100,000 worth of bonds on his pending charges.
Okay, then anything further on that, Mr. Hartwell? I've got no concerns on that.
Yeah, nothing further, Your Honor.
So that's the evading arrest or detention that would stay at 100,000.
No, sir. That one is actually a misdemeanor based on my notes. It would be a manufactured delivery controlled substance offense would remain at $100,000.
Okay. All right, then the court grants the agreement in WR 25-11. The court hereby sets personal bonds on the charges of possession of marijuana, 2 ounces to 4 ounces in the amount of $1,500. Possession of controlled substance, penalty group 3, less than 28 grams, $1,500. These are all personal bonds. Let's see, possession of controlled substance, penalty group 3, less than 28 grams, $1,500. Evading arrest or detention, $1,500. Those all being personal bonds. Court will keep manufacture and delivery of controlled substance, penalty group 1, between 200 grams and 400 grams at a cash surety bond in the amount of $100,000.
Thank you, Judge. I saw that.
All right, I'll get that order signed and filed today, Mr. Smith.
Thank you, sir.
Abraham, who else, sir?
We do not have Mr. Platten. Mr. Vergara tells me that he has gone over his, plea papers. So I don't know if he'll be appearing at 2:00. Mr. Manning is still working on his,
Okay. Was Mr. Platten planning on being here a little bit later?
I told him we had an interpreter at 2:00.
At 2:00, okay. All right, then I guess we'll stand in recess till
I
Mr.
thought he was meeting us at 1:05, so.
Okay. All right, we'll stand in recess and wait for Mr. Manning. Good afternoon, Mr. Phillips. Can you see and hear me okay?
Yes, sir, I can.
All right. Can you see your attorney, Mr. Manning?
Other way.
Hold on. Okay, sorry, we hit the wrong button.
Hey, no problem. Can you see your attorney, Mr. Manning?
Yes, sir, I can.
Excellent. All right, we are now on record in cause number CR 24-80, State of Texas versus William Howell Phillips III, and we are set for docket call today. The docket will reflect that Mr. Phillips is appearing via Zoom from the Kaufman County Detention Center. Go ahead, Mr. Manning.
Judge, I received information earlier this week that the special prosecutor who is handling the case in Kaufman County is no longer working that case. There's a new special prosecutor, and the trial date for the Kaufman County case, which is the more serious of the two cases, has been pushed off until August. So at this point in time, I'm not sure if we need to bench Mr. Phillips over in order to resolve his business over here, or if we continue waiting to see what will happen. I have not had an opportunity to speak to my client since I learned this information, so I don't know if he has an opinion on which route or action that we take to resolve this matter here.
Mr. Manning, do you anticipate resolving his case prior to the Kaufman County trial, or are you specifically trying to not do that?
Judge, I believe that the Kaufman County trial resolution would result in our case being resolved. And so I'd like to wait and see what happens with that Kaufman County case. It does seem like it's stretched out a bit longer, but Mr. Phillips has been in continuous custody of Kaufman County. So he is not being housed here. He's not on our expense. So if he's waiting for trial over there, I don't see any reason why we couldn't wait unless Mr. Phillips would like to take care of his business here. I think we have an offer of 3 years TDC that's been extended if he chooses to offer, if he chooses to resolve his case here in Van Zandt County before the one in Kaufman County.
Do you know if Mr. Phillips is getting credit for his any of his incarceration time? While my docket says he's on bond with Roy Brockway bail bond. Do you know if that's the case, Mr. Manning?
I believe they went off his bond much earlier on, but I can confirm with Mr. Nicholas that is the case.
And that may very well be the case. It's just what my docket says. Sometimes it doesn't get
I
removed.
know after my appointment, there was some discussion about Mr. Phillips bonding out, and so I don't know if they went ahead and went forward with that, but I have not filed anything on his behalf for bond or bond reduction or anything like that.
All right, then I think what we should do then is let's set this for a status in, let's say, set this for status in July 10th. It's a Thursday, Mr. Manning.
Yes, Judge.
You anticipate, will you be in the office that week?
Give me just one moment.
And Your Honor, while Mr. Manning's looking that up, just for the court's information, I do see a order finding the bond insufficient that was signed June of 2024.
Great, thank you, Mr. Hartwell. I do appreciate that.
Judge, I am available July 10th.
All right, let's set it for a status July 10th, and that way we can find out if he's still pending trial or if they resolve the case. If in the meantime, Mr. Manning, you and Mr. Phillips decide that he wants to accept whatever offer is going to resolve this case and wrap that up, then y'all can, that gives you enough time. And then if you want it set earlier, just contact the court and we can get it set, resolve his case, and then he can deal with his business in Kaufman County.
Yes, Judge.
All right, Mr. Phillips, Mr. Manning will stay in contact with you. We'll see you back on July 10th, unless for some reason there's going to be a resolution in your case in which the court will then set it earlier and we'll get that done. Or if there's a change of circumstances in your Kaufman County case, that could make things go faster over here as well. Okay.
Yes, sir. I do have a question. Me and Mr. Manning had discussed lowering my bond potentially in Van Zandt County. Do we need to talk about that now, or is that something we need to discuss at a later point.
You'll need to discuss that with Mr. Manning, and if he wants to file the motion to do that, then you'll file a written motion. He'll request a
Okay.
hearing, then the court will schedule it and give notice to the state.
Yes, sir.
Mr. Phillips, I can come over and meet with you and discuss that. If things have changed on your end, we can definitely discuss that.
Yes, sir. That'd be perfect.
All right, thank you. And jail staff in Kaufman County, thank you. I appreciate you for getting Mr. Phillips hooked up with us today.
Yes, sir. Have a good one.
Thank you.
You as well. You're welcome.
Bye.
All right, Ms. Beal, if you're there, Mr. Platten is on Zoom now. I'll go ahead, before I bring Mr. Platten in, I'll let Ms. Beal get contact with the defendant.
Okay.
Okay, good. And before we get going, yes, have the plea papers been rounded to Mr. Platten? Let me bring Mr. Platten in.
Yes, Your Honor, they were sent yesterday morning.
Okay, I do see him here. Let me go ahead and bring Mr. Platten. Good afternoon, Mr. Platten. Can you see and hear me okay?
Yes, Your Honor. Thank you.
All right. Before we go on record, I'm going to swear in Miss Bill, our licensed court interpreter. Miss Bill, if you'll raise your right hand, state your name and license number for the record. Ms. Bill, do you solemnly swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given in the matter now on trial to the best of your skill and judgment, so help you God? Thank you. And do you have good connection with Mr. Vergara? Very well. All right, we are on record in cause number CR 24-40, State of Texas versus Humberto Luis Aparicio Vergara. And Mr. Vergara, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay.
Thank you, sir. You can lower your hand. And Miss Bill, can you give me the appropriate pronunciation of his last name? I'm saying Vergara, but I think is it Aparicio?
Aparicio?
Aparicio? Okay. My docket is, I think, missing an I, so. All right, sir, is your name Humberto Vergara Aparicio?
Okay.
Are you a United States citizen?
No, Mexicano.
Do you understand, sir, that a plea in this court today to a criminal offense may have an effect on your status within this country that could result in your deportation and your bar to re-entry into this country?
Okay.
Have you taken the opportunity to discuss this with your attorney, Mr. Platten, or any other attorney regarding immigration law?
Okay.
And do you understand your rights and wish to move forward today?
Okay.
And Mr. Aparicio, you are represented by your attorney, Mr. Eric Platten. Are you pleased with Mr. Platten and the work that he's done for you as your attorney?
Okay.
Do you have any questions for Mr. Platten or the court before we go further?
Sí, nomás lo de lo de un papel que me dijo, no lo entendí.
Can Can he be more specific about which document that he needs explanation on?
Ok, uno que se llama de protección.
Oh, the protective orders.
Yeah. Ese no lo entendí, ¿para qué es?
Okay, we'll adjust that in just a moment.
Okay.
Mr. Aparicio, have you understood the other documents that you read and signed regarding your criminal case?
Sí.
Mr. Platten, do you believe that your client is competent to enter into a plea agreement today? And if so, have you explained to him his rights regarding the case? And do you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
I believe he's competent. He knows what he's doing, and he is entering into this intentionally, knowingly, and voluntarily.
Okay, and is it my understanding that as part of this plea agreement, there is an agreement also for the issuance of a order of protection or a protective order regarding the defendant's ability to come into contact or communication with a victim named in this criminal case? Is that correct, Mr. Hernandez?
That was the discussion, Your Honor. It's part of the statute dealing with sexual assault that mandatory protection order will be a part of the plea.
Mr. Platten, did you discuss that with your client?
I did.
Right, and Mr. Aparicio, do you understand that the document that you questioned that you did not understand earlier is as part of the agreement in this case, the court would also issue an order of protection, which says that you will not be able to come within a certain distance of the victim of this case or communicate with that individual as provided by the order. Is that clear to you? Do you understand that?
Okay.
And Mr. Hernandez, let me ask, I haven't reviewed the protective order in depth. Is it a lifetime protective order?
Yes, that's my understanding, Your Honor.
So, Mr. Aparicio, you understand that this order would be in effect for the remainder of your life and the victim's life. You understand the duration of the order, Mr. Aparicio?
Sí.
Okay. All right, Mr. Aparicio, I see that you are charged with a second-degree felony offense of sexual assault. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years and not more than 20 years confinement in prison, and also a possible fine not to exceed $10,000. The plea agreement in your case, the recommendation from the prosecution is that upon your plea of guilty, the court is to assess your punishment at 5 years confinement in prison. In addition, you would have the issuance of a mandatory protective order, and the prosecutors are agreeing to dismiss and not prosecute you on 2 unfiled cases, one of them being a purchase or furnish alcohol to a minor, and the other one being a sexual assault. In addition to those requirements, you would also pay court costs of $290 and reimbursement fees of $85. Mr. Hernandez, what is the credit time that Mr. Aparicio is entitled to?
Your Honor, I think last count, it should have been included. I may need a moment to chat with Miss Abney because I don't have that number with me.
Do you have that number, Mr. Platten?
I do not. I thought that was already in there.
If I may have a moment, Your Honor, I will go check.
Go ahead.
When did the court start using DocuSign?
Probably about a month ago, I think.
Yeah.
We started it early part of April.
It's easy. I hadn't used it until today.
Yeah, that was our hope. We've actually, I say we, Ms. Taberham and I, have been working on it for 5 years, trying to figure
Wow.
out how to make it work. Since COVID, we've been trying to make it work. And so, it finally came to fruition and we've been excited to get it going. And we think it makes things, much more efficient. Just a little bit of a learning curve.
You should talk about that at some judicial conferences and how Zoom and DocuSign, everything's making the world a nice place.
I'm not sure it's going to be that well received in those locations. Mr. Hernandez, what kind of credit time does Mr. Aparicio have?
Through yesterday, April 30th, Your Honor, it's 512 days.
Through yesterday was 512 days?
Correct.
All right. So, Mr. Aparicio, you would receive credit towards that 5-year sentence for 512 days for the time that you have spent in jail up until this hearing. Do you understand that?
Okay.
Okay. So, Mr. Aparicio, at this time, I would ask you, after having explained to you your plea agreement and the range of punishment, how do you plead to the crime of sexual assault, a second-degree felony?
Probably.
Okay.
Are you pleading guilty or culpable?
Okay.
And Mr. Aparicio, has anyone threatened you, forced you, or pressured you to plead guilty to this crime?
No.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Platten, any objection to the stipulation of evidence being admitted?
No, Your Honor.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state at this time?
Your Honor, the state is in compliance and the victim in this matter is in agreement with the offer that was extended.
Thank you, Mr. Hernandez. Mr. Platten, anything further on behalf
No,
of the
Your
defendant?
Honor. Thank you for your help.
Okay. All right, the court's going to review the evidence briefly. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of this offense. The court will follow the plea agreement and recommendation today. The court convicts Humberto Vergara Aparicio of sexual assault, a second-degree felony, assesses his punishment at 5 years confinement in prison. The court orders him to pay $290 in court costs and $85 in reimbursement fees. The court takes into consideration an unfiled criminal offense, purchase or furnish alcohol to a minor, and also a sexual assault in DA 2023-740. In addition, the court finds that the parties have agreed to a mandatory protective order. The court will grant that protective order as submitted, and the court awards Mr. Aparicio credit time of 512 days towards his sentence for the time that he has spent in jail on this cause. Mr. Aparicio, you are hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. If you don't have any further questions, I'm going to have you step over to be fingerprinted with the bailiff. But if you have questions, now would be the time. Do you have any questions, Mr. Aparicio?
No.
Okay, step over with the bailiff. He's going to take your fingerprint.
I think that's all I have, Your Honor.
62.
All right. I'm sorry, Patty, what'd you say?
We have the chapter 62 paperwork, so
Okay, so
We
Jim,
explain it to him.
a copy of it has been provided to him?
I have it.
Okay, and Mr. Platt, did you explain to your client chapter 62 and the effect that it would have on him?
Yes, for life, and that he can't have contact with her. And he'll be in Mexico soon. And I informed him also about registration and all that. It's been covered.
Okay, all right, thank you. If you'll just make sure he gets a copy of that, then he is good to go. All right, thank you, Mr. Platt, and I appreciate you, sir. Holly, thank you so much for helping us out today. Always appreciate you as well.
Have a good day.
Yes, we're adjourned in this case. You as well. Let me take just a moment, to sign these papers before we call this case. Mr. Manning, we're ready whenever you are. If you need time, that's fine as well.
Judge, I have a couple things that are ready, that we can go forward with.
Okay, who would you like to call first?
We can start with Mr. Chavez Torres.
All right, Mr. Chavez Torres, this is cause number CR 24-46. And Mr. Chavez Torres, is he doing a plea today?
Yes, Judge.
Let me look at mine. Mr. Chavez Torres, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Mr. Chavez Torres, are you a United States citizen who reads, writes, and speaks English?
I am not, but I do speak English.
All right, so you're not a United States citizen?
I am not.
Okay. Do you understand that a plea to a criminal offense in this court today may have an adverse effect on your status within this country, including possible deportation and a bar to re-entry into this country?
Yes, sir, I do understand.
All right. And understanding that you still wish to go forward with your plea in this case?
Yes, sir.
All right. And have you ever been diagnosed with a mental condition?
I have.
And are you currently under treatment or on medication for that mental condition?
On medication.
And do you feel like you have a rational understanding of what's going on in this case today?
Yes, sir.
Okay, good. In this case, you're also represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir.
Do you understand everything that you've read and signed today in your plea papers?
Yes.
All right, Mr. Manning, do you believe that Mr. Chavez Torres is competent today and that he understands the plea agreement, his rights, and that he understands the advantages and disadvantages of a deferred adjudication plea, and also that he's doing so intentionally, knowingly, and voluntarily?
Judge, I do believe that today he is competent. I have discussed with him his mental health situation as well as his medication. I do believe that he is able to understand and intentionally, knowingly voluntarily waive his rights in order to take this deal. I have explained to him the benefits and detriments of taking a deferred probation in this case, and I believe he is entering into that and waiving those rights, as I said, intentionally, knowingly, and voluntarily.
All right, Mr. Chavez Torres, you are charged by indictment with a second-degree felony offense of burglary of a habitation that does carry a range of punishment should you be convicted and sentenced to not less than 2 years in prison, up to a maximum 20 years in prison, and a possible fine not to exceed $10,000. The plea agreement in your case appears to be upon your plea of guilty. The state is recommending that the court consider the evidence, not convict you today, but to place you on 4 years community supervision, along with a $1,000 fine, court cost of $290, reimbursement fees of $585, and as part of your plea agreement, you will be placed on the mental health caseload in the Community Supervision and Corrections Department. Is that your understanding of the plea agreement?
Yes, sir.
All right, understanding those things, I would ask you, how do you plead to burglary of a habitation? Guilty or not guilty?
Guilty.
And are you pleading guilty to that because you are in fact guilty of committing that crime?
Because I'm guilty.
Okay. Has anybody threatened you, forced you, or pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No, Judge, and the clarification there was, we had discussion about, while Mr. Chavez is pleading guilty, he wanted to clarify he didn't steal anything from the household. And so I explained to him the law only requires an intent to either commit a felony, commit an assault, or commit a theft. And so he understood that, and that's why he is pleading guilty.
All right, thank you, Mr. Manning. Anything further from the state?
Your Honor, only that the state is in compliance with victim services. All the relevant documentation was sent out to the victim in the case. None of it was returned.
Thank you, Mr. Harwell. All right, the court accepts the defendant's plea of guilt, takes judicial notice of his judicial confession. Stipulation of evidence is admitted. Court, having reviewed the stipulation of evidence, finds sufficient evidence to convict the defendant of the offense. The court will follow the plea agreement and the recommendation. Court hereby defers the finding of guilt on the charge of burglary of a habitation, places Mr. Randy Arnaldo Chavez Torres on 4 years community supervision, assesses a $1,000 fine, $290 in court cost, and $585 in reimbursement fees. And the court places the defendant on the mental health caseload as a condition of community supervision. All right, Mr. Chavez Torres, you're hereby remanded to the custody of the probation department. You're going to step over to be fingerprinted. After that, you'll meet with the probation officers.
All right, thank you.
You're welcome. Who would you like next?
Judge, if we want to call up Mr. Tyson Davis.
Tyson LaCruz Davis. This is cause numbers 2025-11, 2025-82, and CR 24-310. Is Mr. Cruz going to be at plea as well?
Yes, Judge. And Mr. Cruz is the case I was thinking of earlier, that those cases were transferred up. Ms. Taberham was able to get those transferred up yesterday.
Okay. All right, Mr. Cruz, sir. I'm sorry, Mr. Davis, sir. If you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Davis, you can lower your hand. Mr. Davis, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney and the work he's done?
Yes, sir.
Do you have any questions about the paperwork that you signed? That's your plea agreement.
No, sir.
Mr. Manning, do you believe Mr. Davis to be competent? And if so, have you explained to him his rights as they regard each case, and that he understands and is entering into this agreement intentionally, knowingly, and voluntarily?
Judge, he is competent, he understands, and is entering into this plea intentionally, knowingly, and voluntarily.
All right, Mr. Davis, I see that of your 3 charges, Cause number CR 24-310, you were charged by indictment with a state jail felony offense of possession of a controlled substance and penalty group one less than 1 gram. However, I see that today the recommendation and plea agreement would be that you would plead guilty to that offense under the agreement that you would be prosecuted under Section 1244A, which means, Mr. Davis, that you would be convicted as a felon today, but you would receive a misdemeanor sentence. And that agreement appears to be a sentence of 98 days confinement in the Van Zandt County Jail, with you receiving 98 days credit for time served. Also part of the plea agreement, you would be ordered to pay a $1,000 fine, $180 in restitution, $290 in court cost, and also reimbursement fees of $535. The DA's office is agreeing to also consider and conclude 3 other cases, one being unfiled, a criminal mischief, and the other 2 being filed, an unlawful carrying of a weapon, and also possession of marijuana less than 2 ounces. And the unlawful carrying of a weapon that had the weapon seizure, your weapon would be forfeited in this case, and that weapon appears to be a Taurus 9mm handgun. Mr. Davis, is that your understanding of the plea agreement and what you want me to approve?
Yes, sir.
All right, so Mr. Davis, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
All right, and Mr. Davis, has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Court finds that the plea agreement does fall within the lawful punishment range of a state jail felony under Section 1244A, which is maximum up to 365 days in the county jail. Mr. Manning, any objection to the admission of the stipulation of evidence?
No objection as offered.
The stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state, Mr. Hartwell?
Your Honor, only that there are some other pending cases that are the feds are taking up. So just want to be clear for the record that this plea is only taking care of the charges that we have and have active, and that it's not interfering with any potential federal case.
Mr. Manning, is that your understanding as well?
Judge, my understanding is that there is no holds or cases currently filed against Mr. Davis. In addition, Mr. Davis had a conversation with a local federal law enforcement agent who informed him that his understanding was that they were not going to be going forward on the federal cases. That being said, I have explained that this only takes care of Mr. Davis's state charges that were filed here in Van Zandt County, and that any other jurisdiction that may have holds or charges could put those on after the conclusion of this case.
Thank you, Mr. Manning. All right, court is going to review the evidence. All right, the court finds that the stipulation of evidence contains sufficient evidence to convict the defendant of this offense. The court follows the plea agreement today. The court convicts Tyson LaCruz Davis of possession of a controlled substance of penalty group 1, less than 1 gram. The court assesses punishment under Section 1244A of the Texas Penal Code at 98 days confinement in the county jail. Court awards Mr. Davis 98 days credit towards a sentence for time served. In addition, the court orders Mr. Davis to pay a $1,000 fine, $180 restitution, $290 in court costs, and $535 in reimbursement fees. The court also dismisses under Section 1245 of the Texas Penal Code unfiled DA 2023-1099, a criminal mischief. In filed cause number 2025-11, unlawful carrying of a weapon. The court will also order the forfeiture of the weapon seized in conjunction with that offense. And also under 1245 is cause number 2025-82, possession of marijuana less than 2 ounces. Mr. Davis, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. When you are released, if you are not taken into custody on another matter, then I need you to report to the Van Zandt County Courthouse and speak with the district clerk's office about setting up some kind of payment plan so that you can pay off your fines and fees. Failure to do so could result in the court issuing a warrant for your arrest. Do you understand?
Yes, sir.
Okay. All right. Please step over to be fingerprinted. All right, Mr. Manning. Ready on someone else?
Yes, Judge, ready on Mr. Dickerson.
Jonathan Lee Dickerson, cause number CR 25-7. Is Mr. Dickerson a plea today or just a motion for bond reduction?
Judge, we filed an agreed bond reduction on Monday and asked that it be set once we learned it wasn't going to be signed.
So no plea today, correct?
That's correct, Judge.
All right, so it looks like what the state and defense is asking me to do is to set personal bonds on the burglary of a habitation at $25,000, set a personal bond of $5,000 on continuous violence against the family, set a $5,000 personal bond on interference with emergency requests for assistance, and set a $2,500 personal bond on terroristic threat causing fear of imminent serious bodily injury. Show that of all of these charges, his current surety bond or cash bond is set at $37,500. What's the reason for the agreed reduction?
Your Honor, if I could jump in, state has through our follow-ups after receiving the case, we've spoken with the alleged victim in the case. She's given some statements that could be dispositive of the case. While we're waiting to try and confirm some of what she has told us, we didn't want Mr. Dickerson to be spending more months in jail while we're trying to follow up if it ends up, in fact, being dispositive of all of his cases.
And when you say dispositive, do you mean the state dismissing all charges?
Correct, Your Honor.
You don't mean dispositive that he takes a plea on one of these?
Correct, Your Honor. If everything checks out that we received from the alleged victim, we would be, I expect we'd be dismissing all charges.
And Mr. Manning, do you know, does Mr. Dickerson have any ability to make any kind of cash or surety bond on any of these charges?
No, Judge. Personally, he does not. When I spoke to him about what assistance he could receive from family or friends, it sounds like the minimum they could come up was between $250 and $500 for some of a bond. However, Judge, I can call my client or relate to the court that he has informed me he's never been charged with bond jumping or failure to appear. He does have a place of residence at his mother's house here in Van Zandt County. He's lived here his whole life. He will be able to get a job when he gets out, and he has shown up to court in the past and not had any problems with continuing to keep up with his cases when asked to by the court.
Does he have any criminal history?
Judge, I believe he may have some criminal history. I did not get into what that was.
Okay, do you want to talk to him about that, or do you want to call him? Those are things that I have to consider under 1715.
Judge, are you still able to use the,
I can,
not-
I can pull his criminal record, by going into the PSRS system. I can do that. And I will do that, if you want me to.
Judge, if you would like, let me speak to my client real quick.
But go ahead, Mr. Manning.
Judge, it is my understanding from speaking to my client that he has been to the penitentiary, once previously for, a manufacturer and delivery, case. I believe that was for 10 years is what he relayed to me.
All right. While I appreciate the agreement between the state and the defense, I'm concerned that, and I appreciate the state indicating that didn't want him sitting in jail if the case is going to be dispositive. But the fact of the matter is he's been arrested for this matter and he's been indicted by the grand jury and held over for trial. So I'm going to deny the request for the specific bond amounts for personal bond. The court will take it under advisement, and I will consider his financial ability to be able to post a bond somewhere between $250 to $500. So I will take that in consideration, Mr. Manning, and I'll make a ruling on it, and I will send out the order to both defense and the state.
And Judge, since that's the case, I would request that we go ahead and set him on the jury trial docket. That way, if we are not able to get the information from the complaining witness, we can go ahead and proceed with my client's protecting his rights before jury.
Court will set Mr. Dickerson to jury selection beginning June 2nd. I believe our that'll be the next available trial docket, June 2nd.
Judge, next ready on Mr. Sperling.
Eric Glenn Sperling, cause number CR 22-157. Mr. Sperling, sir, if you will raise your right hand, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can lower your hand. Mr. Sperling, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Ever been diagnosed with a mental condition?
No, Your Honor.
All right, and you're here today on a motion to adjudicate or revoke, is that correct?
Yes, Your Honor.
Let me see here. And it looks like with regards to that case, you were before the court on October 12th of 2023, and you pled guilty and were convicted of tampering or fabricating with physical evidence, a third-degree felony. The court heard the evidence and followed a plea agreement between you and the state in which your punishment was assessed at 10 years confinement in prison, along with a $2,000 fine. On that day, the court then suspended the sentence as part of the plea agreement and placed you on community supervision for a period of 10 years. In that period, the state filed its motion to revoke your community supervision, and they alleged 5 separate counts. Have you had enough time to read that motion along with those counts and discuss the same with your attorney, Mr. Manning?
Yes, Your Honor.
And are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, Your Honor.
Do you have any questions about the paperwork that you have signed as part of your plea agreement?
No, Your Honor.
And I see here, Mr. Sperling, that upon your plea of true today to the motion to revoke, the state is recommending that the court revoke your community supervision and assess your punishment at 4 years confinement in prison in order you to pay the balance of your fines, court costs, and reimbursement fees. And I believe that you would receive some credit time towards your sentence. Mr. Manning, how much time would Mr. Sperling be entitled to?
Your Honor, we've calculated and agreed to 386 days credit.
386 days. So, Mr. Sperling, you would receive that 386 days credit towards your sentence for the time that you spent in jail. Is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Manning, do you believe Mr. Sperling to be competent today to enter into this agreement? Do you believe that he's doing so intentionally, knowingly, and voluntarily?
I do, Judge.
And you've explained to him his rights regarding this case.
I have.
All right. And does he waive the formal reading of the motion to revoke and intend to plead true to all counts?
He does waive and so intends to plead true to all counts.
All right, Mr. Sperling, as to counts 1 through 5 contained in the state's motion to revoke, are those counts true or not true?
True.
And Mr. Sperling, has anybody threatened, forced, or pressured you to plead true to any of those counts?
No, Your Honor.
All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the defendant's waiver of rights and plea of true being admitted in evidence?
No, Your Honor.
All right, that is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest my close, Judge.
All right, based on the evidence presented to the court finds that Eric Glenn Sperling has violated the terms and conditions of his community supervision. Court finds all 5 counts alleged in the state's motion to be true. The court, pursuant to the plea agreement, revokes his community supervision and sentences him to 4 years confinement in prison. Court orders him to pay the financial obligations, his fines, court costs, and reimbursement fees. The court awards Mr. Sperling 386 days credit towards his sentence for the time that he spent in jail on this cause. All right, Mr. Sperling, once you're released from TDC, if you've not paid off your fines and fees and all that, you need to report back here to the courthouse so that you can avoid being rearrested for failure to follow the court order. Do you understand?
Yes, Your Honor.
All right, good luck to you, sir. I'm gonna have you step over with the deputy to be fingerprinted.
Thank you.
You're welcome. Ready on anyone else?
Judge, I just received the paperwork for Mr. Slough and Mr. James. So if I may just have a moment to go over their stuff and then I should be ready to go on the rest of mine.
Yes, sir. Court will stand in recess.
Thank you.
Your Honor.
What's your office book after that? Actually get what the office book.
They think I would do them.
Well, I gotta go out.
Epidural, steroid or something.
What'd you do that?
Any more than my team, with sugar and arthritis.
Yeah.
So it's happened.
After a few years.
That's the last thing.
Years. What?
Which is the main infection for my nerves.
That's cool.
As long as they try to pay for it. I mean, it's-
That sounds scary to me. What do you do? Angry past 2 days. What's real with that? Oh, you got a ton of stuff.
Are we ready?
Judge, I believe we're ready on Mr. James. Gisela James.
All right, Mr. James, if you'll come forward, sir. This is cause number CR 24-236, State of Texas versus Gisela James. Mr. James, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Your name is Gisela James, is that correct?
Correct.
And Mr. James, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney and the work that he's done for you?
Yes, sir.
Do you understand everything that you have read and signed in your plea agreement?
Yes, sir.
Do you have any questions about anything before we proceed?
Any questions?
No, sir.
If you do, it's okay, and now would be the time to ask it. It would be better to ask now than to worry about it later.
It said like it is what it is. I have really no criminal background. As a criminal, unauthorized use, it's a felony now and all that, and I got that. And I had never been to prison, but do this court label me as a criminal, I have nothing else to say but to take what is given. You
Is
know.
there anything about the plea agreement that you don't understand? You understand what you're agreeing to,
Yes, sir.
and you understand what's going to be
Yes, sir.
what's actually going. You're going to be. Looks like you're. I was about to get to that, but let's go and talk about it. Looks like you're going to plead true to some of these violations, and
Judge, actually, the only violation he's pleading true to is a failure to report. That failure to report was for while he was in custody for a case that has never been filed, has not been prosecuted to our knowledge, and he's never been arrested. He's never been arrested on specifically for that charge. As he mentioned, it was for an unauthorized use of a motor vehicle out of Louisiana. We have requested that he go back on probation, but the state and the probation department the probation department was unwilling to put him back on probation. And so that's why we ended up with this offer from the state.
so you're telling me that Mr. James is waiving any defense that he has on the failure to report?
Yes, Judge.
So it appears, Mr. James, that upon your plea of true and waiving a defense to that allegation in that plea of true, you're agreeing to allow the state to prosecute you and recommend that the court revoke your community supervision, adjudicate your guilt. That means convict you of that offense and assess your punishment at 3 years confinement in prison, in which you would also receive in order to pay your balance of your fines, court costs, and fees, and you would receive credit time towards your sentence. What is that credit time, Mr. Meany?
144 days credit.
You would receive 144 days credit time for the time that you've already spent in jail. Is that what you're asking the court to approve, Mr. James?
Yes, sir.
All right, Mr. Manning, do you believe that Mr. James is competent, that he understands the plea agreement? He's entering into it intentionally, knowingly, and voluntarily, and he understands that he may have a defense to the counts alleged in the state's motion, and that he's waiving the same?
Judge, he does understand, and I have explained to him what the consequence would be to pleading true to count 2 in the state's motion.
And the state's agreeing to withdraw count 1, is that correct?
That is correct, Judge.
And so I want to make sure that we're very clear on the record. There is a plea bargain being had here between the defendant and the state. The state is withdrawing count 1, which is allegation of a new offense, I believe.
That is correct, Judge.
And Mr. James is withdrawing his defense to count 2. And that is a bargain. That's the exchange of benefit between the state and the defense, correct?
Yes, sir.
Do you agree, Mr. Manning?
Yes, Judge.
All right, you as well, Mr. Cromwell?
Yes, Your Honor.
Okay, what I don't want the record to indicate is that he had a defense and he waived it. But there is a bargain going on here because the state could not withdraw count 1, and it could prove up count 1. And if it did, then that could be a ground for the court to find that he's violated his community supervision and subject him to revocation and sentencing as well. Am I clear on that?
That is correct, Judge.
All right. All right. So, Mr. James, let me ask you, Mr. Manning, does Mr. James waive the formal reading of the state's motion to adjudicate?
He does, Judge.
All right, Mr. James, having read that motion to adjudicate, having the assistance of your attorney, Mr. Manning, this time the court finding that the state has agreed to withdraw count 1 in the motion, how do you plead to count 2 in the motion? Is that count true or not true?
True.
And are you pleading true to that? Well, I understand why you're pleading true. Has anybody threatened you, forced you, or pressured you to be true?
No.
The court will accept the defendant's plea of true to count 2. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true in evidence?
No objection as offered.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense, Mr. Manning?
Nothing from defense, Judge. Rest and close.
All right, based on the testimony before the court finds that DeSella James has violated the terms and conditions of his community supervision. Court will follow the plea agreement today. The court hereby adjudicates the guilt of Mr. James, convicts him of evading arrest or detention with a vehicle. The court assesses punishment pursuant to the plea agreement at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations, which includes a fine, court cost, and reimbursement fees. And the court awards Mr. James 144 days credit towards the sentence for the time that he has spent in jail on this cause. Mr. James, whenever you're released from TDC, if you've not paid off your fines, fees, and costs, you'll need to report to the courthouse and speak with the district clerk's office, make a payment plan, or pay those in full. Failure to do so could lead to you being arrested for violating the court order. Do you understand?
Is that in Texas?
That is in Texas, yes.
Yes, sir.
All right. If there's nothing further, then Mr. James, you're hereby remanded to the custody of the sheriff so he carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Mr. Manning, who are you ready on next?
Ready on Mr. Slough, Christopher Slough.
This is cause number CR 24-149, State of Texas versus Christopher Paul Slough. Mr. Slough, sir, if you'll raise your right hand. Is this a plea today, Mr. Manning?
Yes, Judge.
Mr. Slough, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can lower your hand. Is your name Christopher Paul Slough?
Yes.
And Mr. Slough, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes.
You understand everything that you have read and signed today in your plea agreement?
Yes.
Mr. Manning, do you believe Mr. Slough to be competent to enter into this agreement and that he's doing so intentionally, knowingly, and voluntarily after you've explained to him his rights?
Yes, Judge.
All right, Mr. Slough, you are charged by indictment with a third-degree felony offense of online solicitation of a minor that does carry a punishment range of not less than 2 years in prison up to a maximum 10 years in prison. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending that the court convict you of this offense and assess your punishment at 5 years confinement in the Texas Department of Criminal Justice. In addition, they're recommending that the court assess court costs of $290 and reimbursement fees of $50. Mr. Manning, what kind of credit time is Mr. Slough entitled to?
Judge, we have agreed that he is entitled to 391 days credit.
Mr. Slough, is that your understanding of the plea agreement?
Yes.
All right, understanding those things, Mr. Slough, how do you plead to online solicitation of a minor?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No.
Court accepts the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
The stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court will consider the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of this offense. The court will follow the plea agreement. Court hereby convicts Christopher Paul Slough of online solicitation of a minor, assesses punishment at 5 years confinement in the Texas Department of Criminal Justice. The court orders him to pay court costs of $290 and reimbursement fees of $50, and the court awards Mr. Slough 391 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Slough, you're hereby remanded to the custody of the sheriff. I'm gonna have you step over to be fingerprinted. And just for purposes of the record, the court does find that Mr. Slough, having been prosecuted for an offense under Chapter 62, finds that he was provided supplemental admonishments for sex offender registration, and that a copy of Chapter 62 was provided to him during the plea. Who's next, Mr.
Judge, this is Mr. Dennis Jones.
This is cause numbers CR 24-167, CR 24-274, State of Texas versus Dennis Ray Jones. I believe we're set for docket call. Go ahead.
Yes, Judge. We, at this time, my client has rejected the offers made by the state, request to be set on jury selection docket. Judge have explained to him that once, he's set on jury selection, that he may not receive an opportunity to receive any additional plea offers, or the court may not accept any additional plea offers if those are extended. He did ask that I make a final counter offer to Mr. Hernandez regarding resolution of one of his cases, but not both of his cases. And so I told him that I think it'd be best for us to go ahead and get in line for jury selection, and then Mr. Hernandez and I can discuss Mr. Jones' request for resolution of one of the cases, but not the other.
Very well. Court will set Mr. Jones for trial in each case on June 2nd. If Mr. Jones is not reached for trial that day, then he'll continue on the court's rolling trial docket. We are on the record, cause number CR 22-192, State of Texas versus Joseph Leon Parks. The court's motion to adjudicate, motion to revoke. Court finds that Mr. Parks is still verified in custody in Hunt County. Any update from the defense?
Judge, Ms. Abraham informed me that she did send a second request or third request for Hunt County to have him benched over. Hunt County refused to honor that request. I proposed a resolution for the case based off of Mr. Parks' sentence in Hunt County, but I believe the state needs some time to discuss that and to decide whether or not they're going to proceed with prosecuting Mr. Parks or disposing of this case another way.
Has Mr. Parks concluded his business in Hunt County?
Yes, Judge.
So he's waiting on a trip to TDC, I presume?
I believe so, yes.
And that's why Hunt County will not, because they've already ordered a ticket for him and they're supposed to turn him over to the custody of TDC.
My understanding is the first time we requested him to be bench warranted, he was not resolved in Hunt County. They just didn't honor that. I don't know for the reasoning as for the second and third times.
But you do believe that he's resolved his sentence and he's awaiting a trip?
Yes, Judge. Yes, Judge.
Do you know what kind of sentence he took?
It was 18 years TDCJ.
And here we have him on state jail felony, unauthorized use.
Correct, Judge. I requested that he be discharged, unsuccessful from probation. Like I said, that the state was needing to consult as to whether or not they were going to do that.
Okay, let's reset Mr. Parks for status. Let's set him out to July, so you'll have a little bit more time, but I don't want him to fall through the cracks. Let's set for July 10th. And Mr. Hartwell, if y'all can decide if you want to, by that time, he should be in TDC. If you want him back, if you want to prosecute him or resolve the case, then request a bench warrant and we'll get it issued once we find out where he ends up at TDC. Otherwise, if you're going to dismiss or something of that nature, then just file that.
Yes, Your Honor. Thank you.
Randy, do you have any other clients?
Yes, Judge. We have Mr. Cromwell.
Phillips Shane Cromwell, CR 24-309. And go ahead, Mr. Manning. I show that we're set for docket call.
Judge, we're also set for a bond issue.
What's your announcement on docket call, and then we'll take up the bond?
Judge, the same announcement as we had the first settings. Defense is ready and request a speedy trial. as we requested at the March 24th setting.
Got an opening next week if y'all can be ready on Monday. Got a jury coming in and all.
Judge, I can speak to my client, but we could possibly do that.
I don't think the state could be ready for that. I'm just joshing a little bit here. Let me look here at my special settings. Ms. Tabraham,
Yes, Your Honor.
I think my calendar is up to date. It looks like our next available special setting would be November 17th. Does that sound right to you? Brett Turnage is our November 3rd.
I'm sure, Your Honor. I thought February of 26 would be our next one.
Well, that's why I was checking with you. I don't have anything written on. Let me check my phone here. It's got updated calendar.
Judge, I believe I'm specially set on Mr. Nash in November.
Yes, we have Mr. Nash and then we have Mr. Rowe, Patrick Rowe,
That's correct.
Mr. Session in December. All right, court sets Mr. Cromwell for special setting for jury trial on February 9th. If there's an agreement if there's an opening in the court's trial schedule, if any of the other cases plead out or get resolved in any other fashion and it creates a vacancy, if there's an agreement between the state and the defense to move it sooner, then of course the court would entertain that. I would have to know when such advance notice is to ensure that I could have the appropriate amount of people summoned for this type of offense.
Yes, Judge.
All right, so let's take up looks like there was an agreed recommendation on bond in which the state and the defense have asked the court to lower Mr. Cromwell's bond from $500,000 to $200,000, $50,000 on the charge of murder. Is that correct?
That is correct, Judge.
Okay. And so go ahead and give me what is the reason and recommendation for lowering that on this type of charge?
Yes, Judge, if I may just back up a little bit and give some procedural histories to set the scene. So Mr. Cromwell was arrested on November 7th, 2024 under accusation of murder with bond set at $500,000. He was later indicted on December 24th of 2024, but we were unable to get discovery right away despite multiple requests. On January of 2025, we had an arraignment where Mr. Cromwell pled not guilty and requested evidence at that point in time. And on March 24th, we had our first pretrial setting where Mr. Cromwell requested a speedy trial to assert his innocence before a jury on these charges. At that point in time, that request was denied. And so Mr. Cromwell requested that we seek a bond reduction as he has been in jail since November 7th of 2024. I reached out to the state and this was the agreement we were able to come up with. Bond is set so that we assure defendant's appearance at trial, so that it's set in an amount that's not oppressive, takes into consideration the nature of the offense, the ability to make bail, and the future safety of the victim and the community. If I may, I would like to call my client for limited purposes of bond, the bond reduction hearing, to ascertain some of the information that would go towards those considerations before the court.
All right, the court will allow Mr. Cromwell to be called to testify for the limited purposes of the motion for bond reduction. Mr. Cromwell, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Make sure during your testimony, just speak one at a time. Allow Mr. Manning to finish his questions before you can answer. My court reporters here in the courtroom, it's hard for her to type down if you start answering while he's still finishing his question, okay? Go ahead, Mr. Manning.
Thank you, Judge. Mr. Cromwell, how long have you lived in Van Zandt County?
9 years.
Okay. And what do you do for work when you are not incarcerated?
I'm a mobile mechanic
Okay. And how long have you been doing that?
for 9 years.
Okay. During your time as a mobile mechanic, were you able to acquire tools and resources and a place of business to fund your family and your lifestyle while on the outside?
Yes, sir.
Okay. And since you've been in custody, have you been able to retain any of that personal property or business property while you've been detained since November 7th?
No, sir.
Okay. And do you have anybody who's able to assist you or willing to assist you in making a bond as it's currently set?
No, sir.
Okay. And have you spoke to bondsmen in an attempt to work out some sort of agreement up to this point? Have you tried to bond out with bondsmen?
Yes, sir.
Okay. How many bondsmen would you say you've talked to in trying to make some type of bond while you've been in custody?
5.
Okay. And do you have family and community ties here in East Texas?
Yes, I do.
Okay. Have you ever failed to appear for court when you've been ordered in the past?
No, sir.
Okay. And have you ever been charged with bond jumping or evading or any type of case like that?
No, sir.
Okay. Mr. Cromwell, since you were arrested on the accusation of murder back in November 7th of 2024, you've asserted that you were innocent of that crime. Is that correct?
Yes, sir.
Okay. And you've been in continuous custody since November 7th, 2024. Is that correct?
That's correct.
You've had 2 court settings and been present for both those court settings. Is that right?
Yes, sir.
And you have not requested a continuance in this case. Is that correct?
That's correct.
How much money would you say you would make as a mobile mechanic when you were working?
4,000 monthly.
Okay. And did you have any bank accounts when you were arrested?
Yes, a joint bank account.
Okay. And is there any money in that bank account?
I couldn't tell you.
Okay. Do you have access to that bank account?
Probably not.
Okay. Did you have any real property, any land or any home or anything that you could put up for collateral?
No, sir.
Okay. Did you have any vehicles or items that could be currently sold to make any type of bond?
No, sir.
Okay. When you were first incarcerated, did you have some of those things that you could put towards making some type of bond?
Yes, sir, I did.
Okay. What happened to your tools, to your shop, to your vehicles? What happened to those?
My vehicles were stolen off the property. My shop was tore down. All my tools were stolen. All my personal effects stolen.
Okay. And have you been able to work or provide for your family while you're incarcerated?
No, sir.
Has that caused you anxiety?
Yes.
Have you been worried about what's going to happen every time you come to court?
No.
And are you hindered from being able to assist in the preparation of your defense while you're in custody?
Yes.
Your Honor, in light of those things, I'd ask that it is reasonable for his bond on this type of charge to be reduced due to his ability to make bond and for bail not to be oppressive. I think we have offered sufficient evidence for a agreed reduction to $250,000.
Mr. Hartwell, your witness.
Thank you, Your Honor. Your Honor, by way of addressing any criminal history, would the court prefer that I ask this witness or proffer to the court?
Why don't you ask, and then if he doesn't give you all of the information you know, then you proffer.
Thank you, Your Mr. Cromwell, do you understand that the court has to consider your criminal history when making a decision on bond?
Yes, sir.
Have you ever been convicted of a charge involving assault?
Yes, sir, I have.
And is that a family violence or non-family violence?
Non-family violence.
Okay. And have you ever been convicted of any kind of felony?
Yes, sir.
And can you explain to the court what that felony was?
Possession of narcotics.
And was that, do you recall what level of felony that was?
No, sir, I don't. I know the date, but not the level.
Do you recall whether you were transferred to the penitentiary?
No, sir, I wasn't. I received a 1244A.
Okay. Do you have any history outside of Texas?
Yes, sir, I do.
Where else do you have history?
Just in Florida for a short time.
And what, if any, convictions do you have out of the state of Florida?
I believe I have one. I believe
Do you recall what that was for?
possession of marijuana.
And Your Honor, no further questions.
Mr. Manning, any further questions of this witness?
None from defense, Judge.
All right, Mr. Manning has summarized his request. Mr. Hartwell, any request on behalf of the state?
No request, Your Honor.
Okay, but the state is in agreement with Mr. Manning?
Yes, Your Honor.
Okay. All right, of course, going to take this under advisement. I will also review the PSRS system as I'm required to do statutorily, and I'll issue a ruling and provide it to the parties.
Thank you, Judge. Judge, I believe that concludes my business. May I be excused?
Let me double check with my supervisor. Ms. Supervisor, do you believe Mr. Manning's done?
Yes, Your Honor.
Ms. Supervisor, is Mr. Manning free to go?
Yes, Your Honor.
Thank you, Mr. Manning. Have a good day, sir.
Thank you, Judge.
We will see you shortly.
Yes, ma'am. Thank you, Mr. Hartwell. Thank you, Mr. Hernandez.
Thank you, Your Honor. Have a good day.
as
Thank you
well.
very much, Judge. Have a good day. Bye-bye.